Start having them just do the online course and take their little test at the end of it, and we'll be good. At the most recent training that I went to, put on by a law firm, the law firm that we use to defend discrimination claims, they're saying that the EEOC now, their bar for whether or not you are taking sexual harassment claims seriously is that you train on sexual harassment and discrimination with your employees at least twice a year, and one of those in-person, body in front of the room training type situation. So they've just kind of raised the bar again through case law on how seriously you need to take this as an employer. So let's get deeper into discrimination and talk about how Title VII and that law has created this whole new realm of harassment, illegal harassment that we have to deal with. And really what we're talking about here, the end goal, is not just to be compliant with the law, but to have a respectful workplace where people are comfortable coming to work and getting their job. So our objectives in this section are to look at the legal foundation of discrimination, look at harassment as a form of discrimination. Do all of you, is that the way you've always thought of it, that harassment is discrimination? Most people don't. Most people think they have a very broad view of what harassment is. Think that they can't be subjected to it. But we're going to talk about the difference between harassment and illegal harassment as a form of discrimination, because that's important for you as supervisors to understand. We'll talk about the impact of harassment claims, defending claims of harassment, reporting of discrimination and harassment, and then your responsibilities as supervisors when it comes to harassment. So again, we saw this once already today. Title VII of the Civil Rights Act says you cannot discriminate based on race, color, religion, sex, which meant gender, and national origin. The ADA, the Americans Age Discrimination Act, made it illegal to discriminate against someone 40 years or older. And then the ADA prohibits discrimination based on someone's qualifying disabilities. So that's our list now of federally protected classes, is what we call them. So when I talk about protected class, I'm talking about race, color, religion, gender, national origin, age, and disabilities. Forgot that I had that there. Yeah, those are the protected classes under the federal law. We've also got the Utah Anti-Discrimination Act, which it also prohibits race, color, religion, gender, and the ones that are in red all lead to the whole issue of harassment and hostile work environment. That's why I've highlighted them. National origin, age, disability. Now, it's a violation of state law to discriminate against someone for sexual orientation. That is still undetermined in the federal courts. The U.S. Supreme Court hasn't had the guts to take that one on quite yet. And gender identity, same thing. So if someone comes in and they have a specific sexual orientation, or they identify differently than their born gender, cannot discriminate against them for that. And that's a lot of different ways that you cannot discriminate against them for that, right? And this goes not only in the workplace, but remember, for those of you who run facilities, you can't discriminate against the public for these things either. You can't say, sorry, because you don't identify as the same sex that you were born as, you can't use our bathrooms in the library.
Well, what bathroom do you allow to use?
We always.
You have to have a policy on how you handle that situation.
We have a lot.
We just have one family bathroom in a lot of our libraries. So it's family bathroom, there's no bathroom. But like, what about here in the courthouse?
We don't have a policy.
Unisex or something like that. Also under the Utah Discrimination Act is religious liberty, which is not a federally protected class. But again, if somebody wants to speak about their religion and be open about their religion, you cannot discriminate against them for doing that. There are certain ways that you can limit it in certain circumstances if it's disruptive, but you can't say, well, he's a zealot for his religion, so we don't need him around here.
If a male walks in my female locker room because he says he's female that day?
You need to have a policy on how you're going to handle that situation, because under the Utah state law, you cannot discriminate. If he identifies as a female, yeah, there's a whole...
We're calling wedding.
I'm kidding.
But I can ask him to go, her, him,
Yes.
them, I can ask them to go in the family locker room,
Yes.
because that can be our.
That can be your policy.
And if he refuses, I just make a phone
Yes.
How do you even
call.
That's
know?
why you have Mike Olson on the speed dial and Mary on the speed dial.
No, just wait.
Wade hasn't identified yet, how's he gonna help?
That's why.
Yeah, we're all getting punchy now. This is the wrong time to get presentation. Okay. So all of those laws, all of those different classes that you can't discriminate against, again, you can't discriminate against, as an employer, you can't discriminate against them in the recruitment process, the selection process, the promotion process, discipline, training, or any other action that alters the terms and conditions of employment, which is really broad, right? I mean, that came about through the case law, that, well, it wasn't one of these, but it did alter the terms and conditions of employment, so you discriminated against them. The most outrageous argument I've heard here is there was a case in California that was before one of the appellate courts there a year or two ago. I don't know if they ever resolved it, where a woman claimed that she was being discriminated against because of her age and sex, because she was moved from her desk near the window to a desk in the center of the office where she no longer had a view out the window anymore. And the lower courts had determined that that altered the terms of her employment to the extent that they were discriminating against her, and it was moving its way up through the appellate courts. That's California. So does everybody understand discrimination? What you can and can't do there? I mean, we've all grown up with that. Pretty basic, right?
How are you going to keep them, say if a man wants to go in the women's restroom, how are we going to stop him from doing that?
Well, first off, he's gonna be dressed like a woman.
Well, you look on their forehead, they either say
You can
male.
see that, unless we're right there, and then we got this case happening to us immediately.
Yeah, right.
We'll just have a designated bathroom as a unisex bathroom and have them go there.
Yeah.
And
you'll-
the women's downstairs be up here.
Right.
So you should, it'd be best to placard those restrooms as male gender, male identity, female gender, female identity, and then the others is any gender, any identity. But that's a single stall, of course. Right? It creates a whole mess of problems that unfortunately a lot of the legislators in Salt Lake don't see them, because buildings in Salt Lake haven't had unisex bathrooms for a long time. So they don't see them. It's a difficult situation, and this is all trying to be sorted out in the courts now. like I say, it's undetermined at the federal level on some of these things, so.
How about in our jail? Johnny, how about in our jail if we got a man that comes in and thinks that he needs to be put in on our female side?
Again, I'd be talking to the AG's office and DOC on how are they gonna handle that? Did they see that telling them, no, we're sorting you according to your birth gender, if that's discrimination based on their gender identity?
Yeah. Wow. What's that mean, the transition?
Transition of the trustees, maybe, I don't know.
Okay, so let's talk about how we got from discriminating against people on their race, color, religion, sex, age, and disability to harassment. How did that come about? So, first of all, it was just prohibited to have disparate treatment based on those protected classes. Disparate, different. If you treat people differently based on their protected class, that's prohibited. Then they went to, if you treat their access to things based on their protected status, that's also against the law. That's how we came up with this whole reasonable accommodation thing with the ADAs and all of that. And why I say, you need to be able to, it's not just for your employees, it's access to your facilities too. You can't discriminate. The next step in the courts was people who were complaining about these things were being retaliated against by their employers and their coworkers and things. So the courts put an end to that. So any retaliation based on complaints or claims of discrimination or being a witness to claims of discrimination, violation of federal law. The next step in the process was they went from that to harassment based on protected status. So you might not treat them differently in the way you hire and discipline and all of those things, but you're not very nice to them because of their protected status. That was never passed by Congress. It was created in the courts that they said, oh, that's a type of disparate treatment, so we're going to make that illegal. Harassing someone based on their protected status. And being in Minnesota, there was a whole lot of really good Polish jokes that I just couldn't tell anymore. It was killing me. But there certainly was a lot more problematic harassment than that going on. And of course, once you started having harassment for any protected status, the next logical step was harassment that's based on gender. There we go, sexual harassment. And a lot of people think of sexual harassment as something entirely different in a whole separate law somewhere. It's not. It's Title VII. And the interpretation of Title VII by the courts. So when we talk about sexual harassment and what's illegal sexual harassment, and the next step down was hostile work environment. So now you can't harass someone based on their gender. Oh, and even if you make their environment uncomfortable based on their gender, you're violating the law now. It doesn't have to be all out harassment. It can be just, it's uncomfortable.
What if they make your environment uncomfortable? They don't tackle that.
I'll have to show you how you're protected, how you're a protected class. So again, when people talk about sexual harassment and hostile work environment, people's ideas of what those are has become so broad and watered down that we have to distinguish between what is maybe not respectful versus what is illegal. If the hostility in the workplace or the harassment doesn't tie back to a protected status, either gender or some other protected status, it's not illegal harassment. Here's how the US Supreme Court defines harassment. It's illegal to harass anyone in the workplace based on race, color, sex, religion, national origin, age, disability, and other protected activity. Because they never know what they're going to, decide is a protected class next, right? So unlawful harassment, and they specified this in their decision, is conduct that's unwelcome, number one. So two people that joke around with dirty jokes in the workplace, no one else hears it, they're both okay with it, is that sexual harassment? If it's not, if it's welcome, if they both freely are a part of it, it's not, doesn't meet the test for illegal harassment. It may still be a policy violation.
But doesn't a man entering a woman's restroom come under that same thing? Their conduct is unwelcome.
Good luck.
But who in that situation is the employer?
It's the government, yeah.
Call me.
Yeah, if there's a woman in the restroom and a man walks into the restroom because he identifies as a female,
Call HR.
one is not the employer of the other. You might have, it might create if the person who's identifying different gender is doing that specifically to harass the female,
Females, yeah.
that she might have a case.
Yeah.
Okay.
Because we're required as the employer to keep our employees safe from that, right?
Yes, to protect them from that. So it'd be your responsibility to keep that from happening. So it has to be unwelcome, it has to be based on one or more protected classes. So he's harassing me because we've been in a feud ever since high school, and so he harasses me about that constantly. So that's a hostile work environment. Is it? No. May not be nice, may be disrespectful, may be a violation of the policy for not treating each other with respect, but it's not illegal harassment. It has to tie back to a protected class. And that activity has to be sufficiently severe or pervasive enough to alter the terms and conditions of employment in the mind of the victim and from the perspective of a reasonable person in the victim's position. So let's break that down. That's a lot of legalese and Mike's not here. So
Yeah, he is.
let's break it down.
He can
Oh, he is still here.
Oh,
Okay.
you can apologize now or later, whichever's good for you. I'm here.
But all the rest of us have to break these things down, because you can read that and know exactly what they're talking about. So the activity is unwelcome. The activity is related to a protected class. It has to be severe enough. And when we're talking about severe, so a racial slur, that's a severe as far as the courts are concerned. A joke about a person's gender may not be very severe, and therefore it doesn't meet the test. Okay? Especially a one-time joke. If it's a one-time situation, it has to be severe to trigger this. Or it can be pervasive. So it's joke after joke after joke after joke. It's happening all the time. Now it's pervasive. And if that situation alters the terms and conditions of employment in the mind of the victim, so the employee says, I just hate coming to work. I can't function well. I'm not efficient in my work because I'm just sitting there waiting for the next time that somebody's going to walk up by my desk and make a comment or tell a joke or post something on the board, and it's just, I can't do my job well anymore because of this. That triggers that now it's illegal harassment. In their mind, or in the mind of a reasonable person in the victim's position. So not only do they have to tell the court, I can't do my job anymore because this is so pervasive. They have to convince a jury that, yeah, I can see where, based on that, what they're telling us is happening, that I wouldn't be able to work if I was in that situation. But if the jury says, no, you're being way too sensitive, what they're doing to you is not pervasive enough and severe enough that it would keep you from being able to do your job, they lose their case. Illegal. Okay? Does that make sense? So you can see where, do you know people who think that harassment is a lot broader than that? Most people I know. Okay. So a few statistics about how prevalent this is. In 1990, there were 6,000 harassment claims filed in the United States with the EEOC. In 2000, that number had grown to 16,000. In 2013, it had grown to 28,000. That's the most recent statistic on numbers of claims that I have. But you can imagine with the Me Too movement, what that has grown to in the last year, 18 months, right? I'm sure that's over six figures now. From a dollar standpoint, $12.7 million of settlements that went through the courts in 1992. That doesn't count the money under the table from future presidential candidates that didn't want it to go through the courts, right? And I'm not saying one side or the other.
Yeah.
I'm old enough to know a few other presidents. 50 goes up to $50.3 million in the next decade. Almost 5 times the amount in a decade. Then up to $1.4 billion in 2013. And that's just the settlement amounts. That doesn't count how much these people spent in legal fees before they got to that judgment. Huge amount of money spent on these. Again, the Me Too movement has just made this area explode. A lot because of legitimate cases of harassment that have now been, people have felt more comfortable with bringing to the forefront, and just the misperception that if you feel like you've ever been treated badly at all, you've got a lawsuit, and that's just not the case. Studies show that at least 40% of women and 10% of men have experienced sexual harassment. And I know, I looked up last night, I Googled this, and the numbers are higher, particularly men. Men's up to 15% in a study that was done in 2017. And I think that's the most interesting part of this. How many of you rarely ever think of men being sexually harassed? Right? But yet, 10% of men have been sexually harassed. So what do we have, about 20 guys in this room? There's about 20 guys in this room, 2 of us, on average, have been sexually harassed.
Colton's one. But not everybody's as good looking as him.
So don't close your mind to your male employees. They may be subject to this. All right. So let's talk about the liability that we have as an employer. So you're vicariously liable for the actions of your supervisors. So what you guys do, the county's responsibility. So we want to make sure that you know your responsibilities when it comes to harassment, because the county's the one that's going to have to pay. That doesn't mean that you might not. This is an area of the law where the courts will often find against the employer for not having trained you well, for not having made sure that you follow the policy, but they also come against you personally for your own personal involvement in it, okay? Especially if you're the harasser. That is your own concern. that's why I say the supervisor is also liable for their own actions. Supervisors, the FLSA defines employer as including any person acting directly or indirectly in the interest of an employer in relation to an employee. Now, I'm sure when Mary identified this group as the group of supervisors to come, it's because you regularly supervise a person or persons in your department, and you have that title of supervisor. But you need to think about people in your department who you regularly depend on to help the new guy, watch the crew, do things like that, that as far as the court's concerned, they might not have the title of supervisor, but when it comes to this, they act in the shoes of the employer, and in this regard, they'd be considered a supervisor. So they need to know when it comes to things like, you need to make sure that as soon as you hear about it, you report it so that it gets investigated. If you have people like that that you work with, make sure they know that. When it comes to the harassment policy, you need to act as if you're a supervisor. Okay? And that's not a big problem based on your policy, because it's not just a requirement of supervisors to report all harassment. Every employee is required to report harassment, whether they're being harassed or they witness it. It's a requirement of employment. So the legal application, harassment on the basis of sex is generally recognized as a form of sex discrimination, which is prohibited under Title VII. On duty and off duty, work-related social gatherings, business travel, all of these things, and wherever county business is conducted, are places where you have to protect people from sexual harassment. So after hours at a conference, a training conference in Las Vegas, and the one employee keeps asking the other employee to come on down and let's have dinner, and then maybe up to my room later, and won't give up on it, harassment that the county's responsible for? Yes. It is. Doesn't matter that they're out of town, off shift. The relationship that they have is because of the employment relationship. So you need to be careful with those sorts of things. And it's not just your employees. Again, Mary said you need to protect your employees from harassment. So customers coming in that are sexually harassing your employees, you have an obligation to protect them against that. You also have an obligation to protect other people from being harassed by your employees. So if your employee is harassing someone from a state agency that you work closely with, you need to deal with that. Okay? Just because they're not employees of the same employer, if your employee's involved, you need to deal with it. Okay? There are two types of sexual harassment as far as the courts are concerned. There is quid pro quo. Oh, I said that the first time. I usually triple that. And hostile work environment. Quid pro quo is the type of harassment that we grew up with and we all kind of understand pretty easily. It's the this for that is the Latin for quid pro quo. It's making conditions of employment based on sexual favors. So the boss says, you want to keep your job, you'll be coming to dinner with me tonight. Okay, condition of employment based on sexual favors. That's quid pro quo. It's committed by supervisory personnel or others that have authority to grant or withhold benefits of another person. So two co-employees that don't have any responsibilities or any effect on the other person's employment, can they have quid pro quo harassment? No. Got to be a supervisor and an employee. The supervisor is harassing an employee. Okay? This type of harassment is absolutely not tolerated by the courts. This is a tough one. And we'll see that when we talk about defending it. Because to defend quid pro quo, the burden is on the defendant to show that there was no tangible adverse employment action, that the employee's employment was not changed in any way as a result of the sexual harassment that was going on, and there was the tangible adverse employment action or the tangible adverse employment action was not connected to the alleged harassment. So yes, the supervisor was continually dogged this employee to go out with him on a date, and she was fired because she had a DUI on the job. You'd probably be able to show that that adverse employment action was not related to the sexual harassment, and so you wouldn't have, that claim would be dropped. Okay? But notice, you have to prove and defend yourself. This is one of those where you are guilty until you prove yourself innocent.
Does the plaintiff still have to prove the first step, the quid, and then you have to defend the quo?
Yeah, I mean, they're going to have to show facts. Yeah, they're going to have to show facts that, yes, he did ask me out on dates over and over again. I kept telling him no. But that's about all they have to do. And the courts, in this case, they take this so seriously, unless you have clear evidence that that's not the case, they're going to believe the plaintiff. Yeah, this is serious now. And those are the only two arguments you can make. You cannot say, well, but she really did. She said no, but not really. You got to see the way she dresses at work, right? And I know I'm being offensive, but it's to make a point. She was fine with it for a while, and then all of a sudden, the switch flipped, and she didn't like me anymore, and I stopped it at that point. You don't get to make any of those types of defense arguments. These are the only two arguments you can make. The court will not hear anything else. Okay? Even if it's true. So let's talk about hostile workplace then. This is two employees. Don't have supervisory responsibility over each other. Or it's more than two employees, it's a group of employees harassing an employee or a group of employees. So this is harassing conduct that creates an intimidating, hostile, or offensive work environment for any employee, customer, or vendor to the point of interfering with workplace performance. So they very clearly, the courts here have brought in others that are not your employees. That's why I say you gotta watch for that. Now, and I dropped the slide, but there's a Supreme Court case where they talk about how Title VII does not prohibit harassing behavior, does not make harassment illegal. It only makes harassment tied to a protected class illegal. Your boss may be a jerk and use poor language, but if that being a jerk and offensive language isn't tied to a protected class, it does not create a hostile work environment as far as the courts are concerned. Does that make sense? Again, might be a policy violation. Might still have some discipline coming, but you're not in court over it. Right? And I make sure that I explain that to employees when I do this with the whole employee group too, so that they understand we want to provide you as productive and respectful a workplace as possible, and we'll keep the harassment, all harassment at a minimum, but understand you don't have a hostile work environment lawsuit dangling out there unless you can tie it back to your gender, race, religion. Because a lot of people think any harassment is illegal right now, right? Now when we get to hostile work environment, notice I don't say defend hostile work environment, it's proving. Because here, it's the other way around. The employee, the plaintiff, the person who says that they are in a hostile work environment has to prove certain things. They have to prove that the behavior was unwelcome, that they weren't asking for it. It was based on gender or other protected class, and it was sufficiently severe or pervasive enough to create a hostile work environment. It changed the ability for people to get their jobs done. It was that pervasive. Okay, does that make sense? And we've actually been defending a case, correctional facility, where one of the females that was having some other disciplinary action taken for some things unrelated, decided to bring her hostile work environment claim that all the guys were constantly harassing her. Well, she had a placard on her desk that they've got pictures of that was shown in the court that said, "Sexual harassment is not prohibited here, it's invited." A placard on her desk. She might have a difficult time proving this up, that it was unwelcome, right? But you need to take those things with a grain of salt. She might have been kidding, right? Does anybody put something, I can understand the person who puts that on their desk, but they really don't mean it. They don't want to be sexually harassed. So be careful. And they also have to prove that it has affected a term, condition, or privilege of employment. So there's something that's been changed in their employment status to be able to have a hostile workplace claim successful in the courts. They also have to prove that the employer had or should have had knowledge and did not take prompt and adequate remedial action. And this is where, as supervisors, it's really important for you. When you see this stuff going on, you can't just turn a blind eye and hope that it goes away, or hope that the person really doesn't mind, because we'll get fried when it comes there. Because these things may keep the employee that's being claimed to have committed the harassment out of the frying pan, but this one, we often get that separate claim of failure to train, failure to take reasonable precaution, and those sorts of things. So do not bury these things. Do the reporting. That's what they have to prove, and then our affirmative defense that we are allowed to provide is the employer did exercise reasonable care to prevent and correct promptly any sexually harassing behavior, and the plaintiff employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer, or to avoid harm otherwise. So we exercise reasonable care to prevent. That's why I'm here today. That's why you do 2 trainings a year, prevention. And correct, and you see it, you report it, you investigate it, and you discipline. That's correcting. Any sexually harassing behavior. And then if typically you have a process that you go through that the employee can grieve their charge of harassment in a couple different stages through the county. And if they decide to skip any of those and go straight to the courts will kick that claim out saying, you had other preventative measures that you could have taken, and you failed to do it. That's one of the defenses that we can use. Right? So don't let people skip steps. Retaliation. Remember, that was one of the things that the courts created out of all of this. And this is another area that the courts are absolutely intolerant of. Every harassment claim that we have defended for any of the counties here in Utah, this is the piece that has created a problem for us in the courts. There's several of them that we've had that the actual harassment claim is pretty week. We probably have that dismissed. But there's a claim of retaliation on top of it, where there looks to be some evidence that other employees mistreated the person who complained, or the supervisor or the employer mistreated him as a result of it. Doesn't matter who it was. Now, you know, we've got one that we're just finally settling out that we paid out almost $1 million in defense costs on a claim that if there wasn't for the claim that the county retaliated against the employee, and her claim was they terminated her entire department. They ripped the entire department just to get rid of her because of her harassment claim. That would have been gone in a heartbeat, but except for that claim. Her actual harassment claim would have been gone, except this retaliation thing is something that the court said, oh, we need to take a look at this. If they really got rid of a whole department just to fire her, that we need to take care of. Ultimately, after 3 appellate decisions, the court said, no, the county didn't do anything wrong, but $1 million in defense to get there. Make sure when somebody complains of harassment and you're going and you're reporting, that everyone in your department is told there will be no retaliation against this person. No comments, no queer looks, nothing. Got it? Because this one kills us. Okay. Yeah. So I put this together just to kind of summarize what we've been talking about here. So if there's no offensive behavior, we are cool. We're in the blue. We've got a productive workforce. Everybody's feeling good. Life is good. Then in comes some offensive behavior. Now the workplace is a little bit less productive, but we're still okay. We're still good to go, even though there's a little bit of offensive behavior going on. Some people are jerks. But if that offensive behavior is unwelcome, now now we're getting close to that. We've got a real problem. And here, the offensive and unwelcome behavior, whether it's welcome or unwelcome, probably dealt with in the personnel policy. And we need to deal with it to get back down here into a productive workplace. Once we go beyond offensive behavior that's unwelcome to where it alters the work, the ability for people to do their work, or it's pervasive, now we've got a hostile work environment and we're getting drugged into the courts. And if it goes all the way to where we've taken some adverse action against that employee in their employment, we've reduced their pay, we've put them in a different department that's not as they don't feel is as good of a place to work, or we've terminated them, now we might be all the way up to illegal discrimination, which is going to be real tough to defend. Does that make, do you have a better feeling after the last hour of what is and is not illegal discrimination? And don't get me wrong, just because it's not illegal discrimination or harassment does not mean that it's not a problem. It's still a problem, and it's still most likely a violation of your policy, and you need to deal with it. But you can be comfortable that you're probably not going to, if you end up in court, will probably be successful in defense. Okay. This is a checklist that the EEOC has put out as far as what you should be doing in the area to meet these requirements of reasonable care to prevent and correctly and promptly deal with these issues. So have a policy that's easy to understand and regularly communicated. And I know that your policy was updated just not too long ago and regularly reviewed. You're doing the training, so you're regularly communicating it. You've got a reporting system that employees know about, and it's fully resourced. So fully resourced means if you tell them that they can go to a person, that person has to actually exist. And they have to know who it is and how to get to them. So your policy says all employees and or witnesses must report an incident of harassment to his or her supervisor or another management official within the department. So another supervisor in the department or the department head. In the event that the behavior is from the employer's supervisor, the victim or witness can make a report directly to the personnel officer or any member of the county commission. If the offending individual is the personnel officer, then you report it to the county board of commissioners. Now, who we report to? Again, as supervisors, you have it. Even though it's required in the policy of every employee, as supervisors, the courts put extra responsibility on you to report every case. Okay? Discipline that is prompt, consistent, and proportionate to the severity of the harassment. And of course, before you get to discipline, you've got to have an investigation. So the policy here in Emory County, like it is almost everywhere, is that all allegations of discrimination or harassment will be investigated. So when you have that employee that comes to you and says, this has been going on, it's unwelcome, I don't like it, it's affecting my job, but I don't want to cause any trouble. So I just want to let you know. What do? You respect their wishes and keep it between the two of you? Absolutely not. You got to let them know. If I'm aware of it, I got to report it. That's my responsibility in the policy. It's my responsibility in the courts as a supervisor. They don't get to tell you that they don't want to do anything about it. An investigation needs to occur. The other thing with that is, I know a lot of people say, oh, okay, I'm going to report this to personnel. There'll be an investigation, but don't worry, we'll keep this completely confidential. I have to report it, but don't worry, no one else is going to find out about this. How are you going to live up to that? The investigation is going to have to interview them. It's going to have to interview the person that they say that harassed them. It's going to probably include interviews with other people in the department who witnessed the harassment, right? Is that confidential? So do not promise confidentiality. You can let them know we will keep this as confidential as possible. People in another department shouldn't know about it. People in Carbon County shouldn't be hearing about it. But you cannot tell them that it'll be strictly confidential and no one will know about it because people will know something's going on. Okay. That's difficult for me because I'm going to a county to do this training next week, who I read their policy last night, and the policy says all reports will be strictly confidential and we will not do it. Well, that's going to be a difficult discussion with the HR director. How did that get in there? Because you can't do that. There's no way you can live up to that. You have accountability for supervisors. You have regular compliance training for all employees, and all supervisors and management know how to prevent, report, and respond to harassment. So that's part of why I'm here today. The other piece of the policy that I want to make sure you understand, zero tolerance of retaliation is the way that they put it in the Emory County policy. Again, there just cannot be any form of retaliation whatsoever. And not just retaliation as you consider it, but you got to think about, man, if it was on the front page that this is what we did, would I be embarrassed? Would I be worried? That's the test you should put it through. There's also a section for false claims. And I know almost every county's policy that I've reviewed has that if somebody makes a false claim of harassment, and it's found to be a false claim of harassment, discipline will be taken against them. Employees should understand that. This is not a tool to use to get at somebody. This really damages people's reputations, family lives, and things of that sort. So employers take that pretty seriously. Okay. The EEOC also puts out some things on recommended prevention programs. We won't get into that real deeply. If you want to do more in the way of prevention of Mary will have this whole presentation. You can take a look at these lists and look at the things that they say you should be doing, and some things that, boy, if you really are into it and want to get some bonus points with the EOC, here's some additional things you could be doing. Training's a big part of this. Make sure as supervisors, you want to make sure that you are assisting and making sure that all your employees are regularly trained on the harassment policy. If you see something that comes borderline close but not quite, at least do more training for the person involved. Because again, I said, one-time incident that's not real severe is not illegal harassment. So one bad off-color joke, okay, I want you to sit down and go through the online training again, because you were this close to being a problem, and we don't want you that close ever again, okay? And assure all employees understand the county harassment policy, specifically what is harassment, how to report harassment, procedures for handling of reported harassment, and prohibition of retaliation. You've got all of those in your policy, so again, it's just a matter of making sure that this is put in front of the employees on a regular basis. You got to address all complaints. You got to be on the lookout for harassment, because remember when I was talking about what the courts were looking at, they talked about that they had knowledge or should have had knowledge. And that's what they'll look at. Just because you say, well, I didn't know that was going on, but yet all the other employees in the department are coming in and do depositions and saying, oh yeah, everybody can see that. They're going to say, you should have known. If everybody else in your department knew, and you as a supervisor are saying you didn't, we're not believing you. You should have known. So you got to keep, not just be prepared to take reports of it, you've got to be watching for it. Okay, don't assure complete confidentiality. You need to assist with the investigation if that's, when we get to that part as a supervisor, and assist in the implementation of discipline if it's indicated. Don't try and, again, discipline in this area needs to be more county-wide, because what one department does in one case, other counties might have to live with going forward, because you've set the standard. So if discipline has been identified and you are to implement it as the supervisor, don't be watering it down. Carry out the discipline. Female subordinate mentions casually over dinner that a coworker once grabbed her chest from behind. This occurred 3 years ago, and the offender no longer works at your location. Is this something that should be reported?
No,
And why not?
gone. Can't do it anymore. It's too late.
This may be one that you don't see that there's a issue right now. It's gone. The person waited 3 years to talk about it, and but they're mentioning it. And if you didn't know that that happened, and that physical contact, I said racial slur was severe. Physical contact, absolutely. One time is severe enough. So this was clearly a case of sexual harassment. No question about it.
So they can still go after that person, is what you're saying?
There's a 4-year, yeah. So, yeah, they could still bring the case if she decided to. The other thing is, again, if you didn't know about it and this type of thing is happening and you're not aware of it, obviously this person didn't know that they were required to report that under the policy. Why are you telling me now, 3 years later? That's a serious case of harassment. You should have reported that immediately. That's your obligation under the, so I'd say yes. Are you legally obligated to report it? No, but the policy and just good best practices, I'd report it and look into it and see how that happened and why it wasn't reported on a timely basis.
There's other stuff going on.
Yes, because it might just be the tip of the iceberg, and there's a whole bunch of stuff going on in that copy room that you never go into, that you don't know about. Customer requests that a female subordinate of yours does not assist him at the counter because of a sexual comment she made the last time he was in the office. Is this sexual harassment? It's not quite illegal harassment because offensive comment or a comment of a sexual nature one time, unless it was really graphic, it's not severe enough to be harassment. But again, you'd want to be looking into it. Probably tell that person, well, we can't assign people to help you at the counter, if you can. But we will definitely look into that and talk with the employee and apologize, won't happen again. But that, again, might be the tip of the iceberg. Okay, so I am going to, I had more quizzes and scenarios to look at. I take it you guys want to get out of here on time rather than drag harassment through the mud any further. So we're going to take one last quick 5-minute break. We'll get started again at even shorter. Let's be back at 22 and we'll wrap up for the day.
What happened? Because of the problem, because of the head trauma? Yeah.
I know that, yeah. Cleveland,
And then Orange Grove, one
we can call them and tell them, but they won't come until they get a little few. Cost effective. And I don't know, they've done away with one life ordinance and use so much for what?
That is too much of his own product. It's not big red.
2 years.
The only reason I was able to get this
I bet he left there on 2 girls, 2 that old guy.
is, I came and did 3 months in Corral and Amber. He said, I said, but you promised me, he said.